Good afternoon, folks. Just going to give probably another minute or so just for everyone to start getting online, and then we'll jump right into it. All right, we'll go ahead and get started here. I know folks are rolling in, so we'll just wait. We'll go through some of our intro slides, and then hopefully a few more people will join us. So good afternoon, good morning. My name is Sarah Nasseri. I'm an attorney at Pollara Mazza. We're presenting alongside my colleague, Matt Kreiser, who works in our litigation and dispute resolution group. And today's webinar is focused on return to work and COVID vaccination policies and all of the good and the bad that goes along with it. So as I mentioned, Matt Kreiser will be joining me. He's an attorney in our litigation group, works actively with the Labor and Employment Group, which I'm a part of, on counseling employers on preventative strategies on top of all the litigation and all that fun stuff that he does there. And again, my name is Sarah Nasseri. I'm an attorney in the Labor and Employment Practice Group and focusing on a number of just compliance, legal or regulatory, as well as just general advice and counsel on policies and so forth. So a little bit about Pollara Mazza. We're a full business law firm focusing on a number of different practice areas, ranging from government contracts to labor and employment, which is what I focus on, to litigation, which Matt focuses on, and a whole list of different areas that we have there. So let's jump right into our webinar. As many of you know, the COVID vaccination policies and all the surrounding decisions and talk about that has been a hot topic for probably months now, and will probably be a hot topic for months to come. We're going to talk a lot about sort of where things are right now and what the environment looks like, as well as regulatory updates and things to look forward to in the coming months, and then really just focusing on what a vaccination policy can and should look like, and what things employers should keep in mind, especially when it comes to accommodations, either under the ADA or for religious beliefs. As well as hopefully ending it with, some just general considerations and things to kind of look for and watch out for as you consider rolling out a vaccination policy, whether it's, a mandatory or sort of a recommended vaccination policy for your workforce. So a lot to cover. So we'll jump right into it. Just a note that if there are any questions throughout our presentation, feel free to type them, and Matt and I will try our best to address them as we go along. In the event we can't, we'll try to leave some room at the end to just kind of handle question and answers. And then, the worst case scenario is we'll receive a list of all questions, and we'll be sure to address each of them separately and individually to those who have asked. So that being said, feel free to ask any questions that you might have, and we'll do our best to answer them as we go along here. So kind of to set the lay of the land here, this slide is needs a little bit of updating here, but essentially sort of what we're looking at right now is about 50% of the United States and the adult population is fully vaccinated. against coronavirus. So, and I believe it's about 66% that's received one dose. So a bit short of what President Biden had set. If you recall, he had set 70% as the sort of goal to reach by July 4th as sort of the goal of a return to normal. But we are close to it, but somewhat short of it at this time. But regardless, many businesses and employers are looking forward to return to normal. I mean, there's been, I'm sure you've seen in the news, a number of different employers and businesses that have, made headlines as requiring their employees to return to the office. One that sticks out in my mind is Morgan Stanley. Or there's other businesses that have sort of set like incentive programs and different ways of encouraging their employees to receive the vaccine before they return to normal. So we're starting to see sort of this different mentality among businesses and employers with regard to how they're going to start bringing their employees back to the office and what their return to normal is starting to look like. Of course, this is all against the backdrop of where we are as a nation with regard to the vaccination rates and sort of the guidance that we're receiving at not only the federal level, but also the state and local level as far as, what restrictions can be lifted for vaccinated individuals, what things need to kind of stay in place. And we'll talk more in depth about various state-specific laws. But on the federal side, the CDC just recently issued guidance, last updated end of May, I think it was May 28th, essentially saying fully vaccinated individuals can resume activities without wearing masks or physical distancing, right? So with this in hand, this is obviously giving employers some less hesitation about bringing the workforce back. But of course, there's some more anxiety and eagerness to decipher what that means for vaccination policies. The CDC actually, the guidance made clear that all vaccinated individuals can resume such activities. However, there is an exception that they put in there for, requirements under state, local, or federal law, and then any rules and regulations that may be implemented by local businesses and workplaces, right? So although the CDC has kind of given the green light on, activities for fully vaccinated individuals, there is some leniency given to how businesses and the workplace are going to set those guidelines for themselves. So obviously it's a little bit difficult when some Americans, or many Americans rather, are still hesitant to get a COVID-19 vaccine. So how do employers sort of balance, requiring vaccinations or encouraging vaccinations? And, the whole kind of threshold question here is, should employers implement a mandatory vaccination requirement as part of their return to work policies? And, our hope is through this webinar, we can address some of sort of the practical, but also legal considerations that are involved in making that decision as an employer. And, we'll talk about things that businesses should take into consideration as far as making that decision. Next slide.
Okay. Thank you, Sarah, and good afternoon, everyone. It's a pleasure to be able to present on this topic to you all today. I think that we're going to have some very good information for you to use in your business. As many of you know, many businesses are now underway in planning for the return of their workforce to the office. And in doing so, many employers are facing the question of whether or not to require that their staff receive one of the available COVID vaccines. And in making this decision, questions often arise, such as one, can a business require its employees to receive a COVID vaccination, one of the available COVID vaccinations? Two, how do businesses go about doing this? And three, what exceptions must be made to any mandatory vaccination policy, if any? And prior to the pandemic, it was not uncommon for employers, especially in the healthcare setting, to require that their front-facing employees receive annual inoculations against certain viruses. The most common one was seasonal influenza. And many jurisdictions have upheld employers' ability to require that their employees receive the flu vaccine based upon their job duties. But in doing so, certain exceptions have to be made under applicable federal law, which we're going to talk about later in more detail. At present, federal law permits employers to require their staff to receive one of the available COVID vaccines. The main federal authority covering COVID vaccinations and employer policies comes from the Equal Opportunity Employment Commission, the EEOC, and the Occupational Safety and Health Administration, otherwise known as OSHA. Under the EEOC's guidance, starting in March 2020, at the outset of the pandemic, the EEOC defined COVID to constitute and pose a direct threat to the health of employees in the workplace. The EEOC concluded that someone with COVID-19 or symptoms of it presents a substantial risk to the workplace at that time. This conclusion kind of paved the way for employers to now later adopt and implement enhanced safety measures, including mandatory vaccination policies. OSHA, while no specific federal authority or law imposes an obligation on employers to enact policies prohibiting the transmission or exposure in the workplace to COVID-19, OSHA's general duty clause requires employers to furnish employees with a workplace that's quote unquote free of workplace hazards likely to cause death or serious physical harm. And with the state of COVID and its rapid spread and the toll it's taken on the health of many Americans and other people around the world, COVID would certainly require or constitute the potential to impose serious physical harm on employees in the workplaces. Thus, OSHA, without specifically stating, expects employers to take reasonable measures to protect their workers from workplace exposure to COVID. And now this may include encouraging employees to receive vaccinations. And employers should be aware that if they choose to forego requiring vaccinations or implementing other enhanced workplace safety measures and to require the return of their employees under circumstances and in conditions where the risk of transmission of COVID may be high, the employer may be in violation of OSHA's general duty clause. And it would not be uncommon under such a scenario for an employee to object to returning to the workplace. And if an objection is made, the employee may be protected under OSHA's anti-retaliation provisions. OSHA prohibits employers from discriminating in any manner against an employee because they have exercised on their behalf or on behalf of others any right afforded to them under the statute, and this includes the general duty clause. And to kind of discuss a little bit more in detail some updates to this federal regulatory authority, I'm going to turn things back over to Sarah.
Great, thanks, Matt. So as a business, I'm sure many of you have heard or looked to both the EEOC and OSHA for guidance, right? I mean, there's a lot of rules and regulations that come out of both agencies that employers are well aware of. And so part of the hope, over the past few months and throughout the course of the pandemic was that we would receive some guidance, in some direction from these agencies as far as how businesses and employers are to sort of manage the pandemic, manage their workforce, and now especially manage vaccinations and how to return back to work. And as Matt mentioned in detail, they sort of have set the stage and have given us sort of the framework by which we can sort of build policies and as of a few months ago, and I'll go into details to exactly, the specific type of guidance that we've received, but, there's still a lot of gray area, unfortunately, with regard to what guidance they've put out. And, there's going to be a lot of room to sort of interpret as you may, depending on the circumstances. But for what it's worth, and I'll start with the EEOC. So back in December of last year, so December 2020, the EEOC released some FAQs where they didn't explicitly endorse vaccine requirements, but they, I guess we could say they implicitly endorsed vaccine requirements for on-site work, and then expressly allowed COVID-19 virus testing. So if you wanted to bring your workforce back, then you had the ability to, require proof of a negative test and so forth. Because, as Matt mentioned, under the American Disabilities Act, employers were allowed to require that employees not pose a quote unquote direct threat to the health or safety of individuals in the workplace. So, back in December, we started getting guidance and a sense of where the EEOC was going as far as, specific to COVID-19. So, it was okay to request proof of COVID-19 vaccination, as that was not considered a disability-related inquiry. But of course, the caveat is that employers have to engage in the interactive process if employees decline vaccination due to a disability or a sincerely held religious belief, which we'll get into in more detail. A few months later, and more recently on May 28th, the EEOC issued updated guidance. I think this was in light of the updated guidance from the CDC, where they explicitly noted that under federal EEO law, employers are permitted to adopt mandatory COVID vaccination policies. So this essentially, sort of gave employers the green light to go ahead and, require vaccinations if that's what they decided to do, and that was the direction they wanted to take. However, of course, any such policies must be subject to accommodations as required under the ADA or Title VII. So this was actually probably a pretty significant direction and sort of guidance from the EEOC, wherein you're now getting, the specific okay to go ahead and adopt a mandatory COVID vaccination policy, but of course, subject to and with the caveat that you're engaging in the interactive process. On the other side, with regard to OSHA, so as Matt, mentioned in detail, the whole sort of theme of OSHA is requiring employers to provide a safe and healthy workplace free from, hazards likely to cause death or serious physical harm. So back in January, OSHA released some guidance, which was actually focused more on how to protect unvaccinated or otherwise at-risk workers in the workplace. So essentially, they set out some protocols and guidance with regard to how employers should engage with workers to determine, different methods and interventions with regard to protecting unvaccinated workers. So things like, instructing such workers to, stay home if they're exhibiting COVID-19 symptoms, implementing physical distancing for unvaccinated workers in communal areas, providing such workers with PPE, and even, sort of encouraging them to go get vaccinated by granting PTO for these employees. So OSHA sort of released some guidance on how to sort of navigate the workplace when you have unvaccinated workers or otherwise at-risk workers. So there are some protocols that they've released that could be helpful and sort of setting the stage for that. On June 10th, they actually updated their January 29th guidance by, essentially now encouraging COVID vaccination. So, most employers who, can, again, it's in line with sort of the EEOC and CDC guidance. So employers are still sort of, recommended or encouraged to take steps to protect unvaccinated workers, but I think it's all with sort of this central theme and notion that if you can encourage your workforce to go ahead and get vaccinated. And something noteworthy also is on May 21st for those on June 10th rather, for those employers that are in the healthcare setting, OSHA released a emergency temporary standard aimed at workers in healthcare settings. So specifically, the standard required certain healthcare employers to take measures to protect their workers in settings where suspected COVID-19 patients are treated or confirmed COVID-19 patients. So certain employees in hospitals, nursing homes, et cetera, were sort of required to implement certain protocols and plans to identify and control COVID-19 in those specific work settings. So, for those employers who kind of fall under the umbrella of, a healthcare, setting, a nursing home, emergency responders, assisted living facilities, and so forth, OSHA has now released certain standards that must be followed and must be implemented with regard to those specific workforces. So there are some exemptions with regard to, workplaces where all employees are fully vaccinated. So, again, you're seeing this sort of general sense from these agencies that vaccinations are encouraged among the workforces, but certainly with certain caveats and with certain ways and protocols by which to deal with situations where you may have unvaccinated individuals and so forth. So there is some guidance that we can look to, and we anticipate that a lot of this is sort of evolving, and we'll sort of obtain more and more updates and guidance as time goes on. But for what it's worth, we do have something to build on, and some sense of direction and guidance from these agencies by which employers can look to in building their vaccination policies. So Matt, I know that obviously with any sort of mandatory vaccination policy, there is going to be certain exceptions and accommodations that employers are required to look to. So go ahead and let us know.
All right, thank you, Sarah. Okay, so should a business decide that it wants to implement a mandatory COVID vaccination policy, generally speaking, if an employee objects to receiving that vaccination, in broad general terms, they can be subject to termination. There's no protection outside of certain defined circumstances that we're about to talk about, or a general right to decline receiving a vaccine. But as Sarah touched on a little bit, Title VII in the ADA requires employers to provide certain exceptions to a mandatory vaccination policy. And the basis for that is there are certain legally protected reasons for employees to choose or not be able to or not be eligible to receive a COVID vaccine, primarily a disability. And now what constitutes a qualifying disability under the ADA can be a whole separate presentation. But for now, let's take a broad term of disability. And for sincerely held religious beliefs. For example, an employee may have a documented history of allergic reactions to some of the ingredients in the available COVID vaccines. And after consultation with their medical providers and the vaccine administrators, they are not a candidate that is eligible to receive one of the available COVID vaccines. Additionally, some employees may present certain mental health issues and experience severe anxiety about receiving a COVID vaccine, given what has happened since the onset of the pandemic. And for some employees, some may believe that receiving a COVID vaccine would violate their religious beliefs. And these are all protected bases to refuse vaccination under federal law, specifically the ADA and Title VII. And as Sarah said a little bit earlier, requesting proof of COVID-19 vaccination is not a disability-related inquiry under the ADA. The reason being is the EEOC has determined that this is not likely to elicit information about a disability. Now, this changes if an employer or business would ask why an employee has chosen not to be vaccinated. And this could elicit information about a disability or genetic information, which is protected under federal law. And under the ADA's disability-related inquiry standard, an employer's request for information that would relate to a disability, such as why did you not receive a COVID vaccine, must be quote-unquote job-related and consistent with business necessity. If not, and it's just general information that you're trying to obtain from an employee, this could be in violation of the ADA. So, now what? When an employee requests for an exemption from mandatory vaccination policy, this should be reviewed depending on a disability or a religious accommodation, to see if the request falls under the ADA or Title VII and the employer's obligation to consider granting to the employee an accommodation. And in doing so, employers should ensure, one, that they have policies in place or review existing policies, those policies are already in place, for handling these requests for accommodation. And two, employees should not be required to use certain magic words to trigger an employer's requirement to engage in the initial steps of the process to determine whether or not an accommodation must be granted. Instead, employers should advise their managers and supervisors to understand how to recognize a request for an accommodation and who to relay that information to in the company should an employee intimate or state outright that they're seeking an accommodation to having to receive a mandatory COVID vaccine. And importantly, it should be stated that a request for exemption to receiving a mandatory COVID vaccine is not protected by federal law on the basis of personal preference. So if an employee would state that they would prefer not to receive the vaccine, that is not protected under the ADA or Title VII. Now, if they say they would prefer not to receive the vaccine because it runs afoul of their religious beliefs, that is a different story. But a general personal preference not to receive the vaccine is not covered. And as I stated a little bit earlier, once an employer receives a request for accommodation to not receive a COVID vaccine under a mandatory policy, the employer should initiate what's called the interactive process to determine whether or not the request to avoid receiving COVID vaccine should be accommodated. And Sarah is going to talk a little bit more about the interactive process, the employer's obligations here in general, and accommodations under the ADA.
Great, thanks, Matt. So as we mentioned, and as Matt went into detail, again, the EEOC has given employers the green light to go ahead and, implement mandatory vaccination policies if they choose to. However, with regard to certain accommodations under the ADA or Title VII. So, of course, as many of you know, American Disabilities Act or the ADA requires employers to provide reasonable accommodations to qualified employees with a covered disability. As Matt mentioned, it is deemed a disability under the ADA. It's a whole list of different things. So there is a broad scope of, qualifying reasons here. But, as many of you probably know, if the accommodation obligation creates an undue hardship and employers can demonstrate that it would create an undue hardship, then employers can avoid that obligation. So again, EEOC guidance reiterated that an employer's obligation to accommodate employees who have disabilities that would otherwise interfere with an employee receiving the COVID-19 vaccination, is fine. Under these circumstances, an employer may have to exempt such employees from the vaccine mandate. So again, as Matt mentioned, once an employer receives any sort of request for accommodation, then, the employer and employee should engage in the interactive process. If there's a need to, obtain certain documentation from his or her healthcare provider, then, employers can certainly do so. Of course, any medical information that's received should always be kept confidential and separate and apart from the personnel file. So that's something to note as far as sort of a practical, lesson. But, for any sort of ADA accommodations, including any accommodations with regard to obtaining the vaccine here, employers are certainly able to ask for certain documentation to confirm, the nature of the impairment, the duration of the need, and sort of anything that would conflict with the employer's vaccination requirement. However, notably, the EEOC has acknowledged that under these circumstances, an employer may deny a disability-related accommodation where there is no available alternative that would alleviate the direct threat posed by an unvaccinated employee. I know Matt touched on this a little bit, but essentially a direct threat is one that poses significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. So, certain things can be taken into account, and employers should probably conduct a individualized assessment and sort of a case-by-case determination as to whether or not a direct threat exists. So you sort of want to look at the duration of the risk, the nature and severity of the potential harm, the imminence of the potential harm, and the likelihood that the potential harm will occur. So in undergoing such an assessment, if an employer determines that a direct threat exists, then the employer may be able to exclude the employee from the workplace, but obviously, if possible, can provide alternative accommodations such as a remote work arrangement or sort of a working from home arrangement. So, I think these sort of alternative work arrangements, especially given that a lot of workforces have been working remotely over the past year, it seems like, such arrangements are generally, okay and should be able to be implemented. But, it's going to be sort of this evolving assessment of what a direct threat is and how sort of that assessment will evolve over time. Because if an accommodation cannot be made, there's obviously certain measures that can be taken in sort of, not necessarily segregating, but, making sure that there's certain protocols in place where unvaccinated workers and vaccinated individuals can, either be physically distancing or the use of PPE and masks and so forth. But as sort of these requirements for masking and distancing start getting lifted in various states and localities, then, how are employers going to assess sort of the imminence of harm and the nature and severity of the potential harm under this direct threat assessment? So sort of a lot of moving pieces to take into account here, but generally speaking, as many of you know, under the ADA, if any employer requests an exemption on the basis of a qualifying disability, then employers can go through a case-by-case analysis as to whether or not that request can be accommodated, and engage in the interactive process, and then determine if there are other means and ways of providing accommodations that may not necessarily be exactly what the employee requested, but may alleviate the situation and may cause for provide a better situation for the entire workforce. So a lot to consider there, and that's just an accommodation under the ADA. But as you mentioned earlier, you can certainly request an accommodation as an employee for a sincerely held religious belief, which falls under Title VII. So I'll hand it off to Matt to go into detail with regard to those requirements.
Sure, and thank you, Sarah. And just to be clear, when we say interactive process, it's really a legal term of art. What does that mean? An interactive process is where the employer and the employee exchange information about the nature of the disability claimed or the religious beliefs claimed, and the limitations that the disability or religious beliefs place on receiving an employer-required vaccination. Essentially, it's a good faith effort on the part of the employee and on the part of the employer to conduct this individualized assessment of the employee's particular circumstances to see if the disability or the religious beliefs can be accommodated. So just keep that in mind as we refer to what the interactive process is. Now, similar to the ADA, Title VII requires employers to reasonably accommodate an employee's quote-unquote sincerely held religious beliefs to not receive a COVID vaccine. The accommodation process under Title VII is similar to that, but has some notable distinctions in comparison to the ADA. Similar to the ADA, an accommodation is required unless there's no undue hardship or undue burden, which can be used interchangeably, imposed on the employer. However, the standard for what constitutes an undue burden or hardship under Title VII is much lower than that under the ADA. And so that's very important to keep in mind, as the standards for what's required under the ADA and what's required under Title VII in the ways of reasonable accommodations should not be conflated. To constitute an undue hardship or burden under Title VII, the accommodation would have to impose on the employer something more than a de minimis cost. We're lawyers, so we have to be at the courts, and everybody has to use Latin whenever they can. So what is de minimis? De minimis means something more than a minimal cost upon the employer. This can include monetary costs, effects on efficiency, safety, and effects on other employees. And now when you compare this to the ADA, which requires that an undue hardship constitute quote-unquote significant difficulty or expense. And you can see how the accommodations in Title VII to constitute an undue hardship is much easier to attain than it is under the ADA. And now, with respect to religious beliefs, admittedly, it can be extremely difficult to determine whether an employee's religious beliefs are sincerely held. And in meeting and receiving this accommodation request at the outset, it's good practice for an employer to ask the employee to provide an explanation of their religious beliefs, and if necessary, documentation supporting their religious beliefs, possibly from a religious leader, and how these beliefs conflict with the employer's mandatory vaccination policy. It is not unusual for an employee to present a set of non-theistic, I'm hoping I'm not butchering that word too much, non-theistic beliefs. And these are beliefs that are outside of traditional religion, as the Western society knows it, and does not necessarily involve believing in a god or gods. For example, should an employee claim that receiving a vaccine, a COVID vaccine, will violate their belief system concerning self-determinism and what affects their body, such beliefs cannot instantly be dismissed. Many courts throughout the United States have determined that non-theistic beliefs can be religious to require accommodation under Title VII. And the EEOC's recent guidance echoes this line of court decisions. So what is a sincerely held religious beliefs? According to the EEOC, a sincerely held religious beliefs are, quote unquote, moral or ethical beliefs as to what is right and wrong that are held by the employee with the same sincerity as that of traditional religions. In general, these beliefs need not be based in tenets of a traditional religion, as I stated earlier, but must occupy a place in the employee's life parallel to that occupied by God and many other religions. And the interpretation of what constitutes occupying a place in their life parallel to that by God and other religions varies by jurisdiction. So it's important to keep that in mind when making a determination of whether or not the employee's religious beliefs are protected under Title VII and constitutes a sincerely held belief. That the ultimate result of the question of whether or not this is sincerely held can vary by jurisdiction. But once a determination is made regarding the sincerity of the employee's beliefs, the employer is required, similar to under the ADA, as Sarah discussed, to engage in an interactive process, that exchange of information with the employee and determine on a case-by-case basis whether the employee's request to not receive a COVID vaccine was based on a protected, sincerely held religious belief and can be accommodated. And you go through the same process as you would under the ADA in determining whether or not accommodation can be afforded, and the types of accommodations that are usually afforded under the ADA would be also generally applicable to accommodations under Title VII. Now, with all that being said, an employer's ability to require mandatory vaccinations under federal law is still subjected to state law, as if that's not enough. And Sarah's going to discuss a little bit more about some limitations that have come up under state law. Sarah?
Yeah, thanks, Matt. So, as we mentioned, we've gone through sort of the federal guidance framework of, what these agencies have advised and, certain restrictions and limitations based on federal law. But, as is the case with a number of other compliance issues, employers, should also be aware of their respective states' laws and pending legislation concerning, mandatory vaccination policies and certain requirements therein. Because, as we're starting to see with a number of other issues, states are kind of, taking things into their own hands and imposing certain additional obligations and, what they deem to sort of be filling in the gap of certain things that the federal laws might not, tend to. So there are certainly, certain state specific laws and requirements that we wanted to at least alert you to. And this list is certainly not all inclusive of everything that's out there. We're, seeing more and more specific state and local laws, coming in. So, we just advise all employers to sort of, keep apprised of any updates in your local jurisdictions, just to make sure that there aren't any additional things that you need to be aware of. Some noteworthy ones we wanted to kind of address are In Montana on, I believe it was early May, maybe May 7th or so, the governor there signed a law wherein essentially Montana became the first jurisdiction to recognize an individual's vaccination status as a protected category. So, employers may not discriminate against or refuse to employ an individual based on whether the person has been vaccinated or possesses an immunity passport or, proof of vaccination. So essentially, the law bars employers from requiring employees to receive vaccines, including the current COVID-19 vaccine, and I think what they're sort of, using as their basis there is the sort of emergency use authorization that was granted by the FDA. So, the sort of theme there is because the vaccine is still sort of undergoing trials and is only allowed under the Emergency Use Authorization Act, that's sort of their basis for, moving forward with this law. But, a pretty strict law and pretty strict requirements prohibiting the requirement for vaccinations in Montana. So something to keep an eye out there. In Florida, again, around the same time frame, the governor there enacted a law that prohibits any business operating in Florida from requiring patrons or customers to provide any documentation certifying COVID-19 vaccination. Essentially, they're prohibiting businesses from requiring customers who come in to provide documentation certifying that they've received the COVID-19 vaccination. Now, the interesting thing here is that it does not, under the Florida law, it does not prohibit employers from requiring such proof from their employees. It's just specific to businesses, vis-a-vis their customers. So, obviously a little bit more forgiving than the Montana law, but again, just, an interesting development there in Florida. And then on the flip side, we have a jurisdiction, or a law coming out of Santa Clara in California where employers are required to obtain a record of their employees' COVID vaccination status or face up to a $5,000 per day fine. So essentially the order, among other things, requires businesses to, certify the vaccination status of all of their employees and personnel. It focuses on sort of COVID-19 case reporting, sort of the policies and protocols in place and so forth. So, you're getting this sort of two different versions of laws, obviously, one where vaccinations are sort of, not necessarily looked down upon, but just, giving businesses more leniency. And on the other side, coming out of California, which is not very surprising, where you're seeing that, you're a business or employer operating there is now required to obtain vaccination status. And, if you don't by a certain deadline, then your business may face pretty hefty fines per day for not meeting those requirements. So obviously this adds, a lot on top of everything that we're seeing on the federal front. But, it's unfortunately for employers and for us attorneys who work with employers, it's nothing new. And we sort of have to take these as they come and develop policies that are, take both of these different fronts into consideration. So I'll turn it to Matt, because I know there are sort of some other miscellaneous and other, significant considerations that employers should take as they decide whether or not to implement their vaccination policies and how to do it. So Matt, walk us through those.
Thank you, Sarah. And to touch on Sarah's points here, it'd be a very good idea and good practice, depending on the location of your jurisdiction, to pay attention and keep an eye out for legislation pending before each state's respective chamber or house, what have you, regarding whether or not mandatory vaccination policies will be permitted. So that would be a good practice. So, and in addition, if all this information is not enough, in addition to implementing or deciding whether or not to implement a mandatory vaccination policy, there are some other considerations that businesses and employers would want to keep in mind. And the first relates to medical information. It is very, very important that if an employer receives any employee medical history related information pertaining to an accommodation request, that this information is confidential. Not only is confidential, must be held in strict confidence and be kept confidential through the duration. So keep that in mind when going through the accommodation process and gathering information of whether or not to grant an accommodation, that any medical information received is protected information and must be kept confidential. Second point is workplace civility. It's important, and you probably have seen this in various social circles or just out and about in public. It's important not to permit coworkers to harass or disparage one another, especially if they're unvaccinated. Regardless of whether the employer ultimately decides to implement a mandatory vaccination policy, it's important to ensure that the workplace remains civil for unvaccinated persons, because those employees may or may not know the particular circumstances of that employee for why they did not receive a COVID vaccination, and that should be kept in mind. Second, it'd be a good idea and good practice for employers to promote etiquette rules about vaccination, emphasize that employees should not ask one another about their vaccination status or why they didn't get vaccinated. It would lead to problems down the road, as we just discussed, regarding disparagement and making the workplace unwelcoming. And employers should also remind their employees that some, even vaccinated employees, may choose to continue to wear a mask in the workplace of their own volition. And wearing a mask does not in and of itself mean that you're unvaccinated. So with these things in mind, it can go a long way to enhancing workplace civility as it relates to the contested issue of COVID vaccinations. Third, for labor unions, there's a separate set of considerations to keep in mind. Employers must remain mindful of the National Labor Relations Board, NLRB's policies, and their obligations under the NLRB's policies and regulations. If you have unionized employees, the starting point is to determine whether or not a collective bargaining agreement permits and or prohibits the employer from implementing a mandatory vaccination policy for its employees. So if the CBA permits it, then you can go ahead and implement a policy. And if not, if it's expressly prohibited, then you have to stop there or collectively bargain again to have that policy changed. And absent specific authorization or prohibition in a CBA, the next step would be whether or not the employer is privileged to implement a policy for mandatory vaccinations unilaterally without discussing the issue with the union, pursuant to a management's rights clause or a comparable provision that broadly authorizes the employer to implement reasonable new workplace rules or policies. And if there's no on-point authority pertaining to whether or not you can implement a mandatory vaccination policy, and there's no broad management's rights clause to access. In the absence of such authority, it's probably the employer is probably going to have to collectively bargain with the union to have a mandatory policy instituted for COVID vaccinations. The NLRB has previously held that in the context of the hospital's implementation of a flu prevention policy for its unionized nurses, which included a requirement that the nurses take a specific antiviral drug or wear a protective mask at all times, was a mandatory subject of bargaining under the NLRA. So it's a good idea if there's no specific authorization or a broad general management clause that to implement a mandatory vaccination policy will likely have to be collectively bargained for with the union. And employers also need to be mindful with their unionized employees. They're not violating the NLRA or taking adverse action against employees who may be engaging in protected activity by opposing vaccination policies or management's consideration of vaccination policies. Or for non-unionized employees, this would fall under concerted activity, which is very broad under the NLRA. So it's good to be mindful for that in the unionized and labor union context. Third, we're seeing it's very common that employers are offering incentives to their employees to receive the COVID vaccination, as opposed to implementing a policy to make these incentives widely available to encourage employees to receive the vaccination so that there does not have to be a policy. In fact, this practice is actually encouraged by the CDC. For the obvious reason is the CDC is trying to get the most people vaccinated as possible. However, as with everything, it's important to keep in mind that there could be the potential for discrimination claims if the incentive to vaccinate is not extended to all employees. For example, if there are individuals who request accommodations under the ADA or Title VII for disability or for their religious beliefs, if the incentives are not made available to them, that could pose an issue under the ADA and Title VII for discrimination on those protected grounds. Also, with incentive programs, there may be possible wage and hour implications. The Department of Labor has not yet taken an official position or offered any specific guidance on COVID vaccination incentive programs, but monetary incentives can be or could be deemed to be a discretionary bonus. So it's good to keep an eye out for that. So in sum, as you probably realized, next slide, please. The current regulatory environment surrounding COVID vaccinations in the workplace is still evolving and will continue to evolve moving forward. For instance, there could be a very different calculus in the fall if COVID variants present a problem or vaccine makers develop a booster to combat the variants, and we have the whole issue springing up again of whether or not the booster should be required. After trying to get the initial vaccine, initial injection or inoculation to say completed. And it's good to recognize that at this time, employers are trying to do their best that they can with a set of imperfect information. And under the circumstances, you have to move forward with what you have in the employer's best interest and best determination, as can be made. Also, it's good to keep in mind that there are pending legal challenges to the legality of implementing mandatory COVID vaccination policies, but at this time, those legal challenges are not expected to be successful, but it's a good idea to keep a watch out if any case law in your jurisdiction comes through determining that mandatory COVID vaccination policies are illegal for whatever reason. And as you've seen, the decision of whether or not to require employees to receive a mandatory vaccination is difficult, and navigating the accommodation process is difficult and has potholes. And there's multiple issues to consider if you're deciding whether or not at this time to implement a mandatory vaccination policy. And if you do, to make sure that you have those backstops set up to account for accommodations requested by employees. And it's critical for employers to assess these policies and ensure that its employees understand how to make a accommodation request to a mandatory vaccination policy. And lastly, to reiterate, it is critical that any health information obtained from employees and medical information and medical histories related to a COVID vaccination accommodation be held with care and strict confidence and confidentiality. Restoring employee confidence and returning to work is important if the employer is seeking to bring their employees back into the office. And a mandatory vaccination policy may be a tool to help increase that confidence in a business's employees. I'd like to thank you for attending today's presentation. And please do not hesitate to reach out to either myself or Sarah should you have any follow-up questions. And Sarah, do you have any additional thoughts or concluding ideas?
Yeah, no, thanks, Matt. Just to reiterate that obviously this is kind of an evolving process, and as we continue to see things evolve over the next few months, then we'll be sure to kind of keep an eye out and see how things work through. But if there are any questions specific to how to draft certain policies or certain considerations to make and accommodations and so forth, please do not hesitate to reach out to Matt or myself. And we hope that you guys enjoyed the presentation and everyone stays safe and healthy.
All right, thank you very much, everyone.